Convenience accounts and powers of attorney, and the problem with springing powers of attorney. If you are concerned about keeping up with your bill paying and banking, consider setting up a convenience account or creating a durable power of attorney. If you are older and concerned about keeping up with your bill paying and banking, you may have considered adding a son or daughter to your checking account. Making someone a co-owner means they can easily help you out by writing checks, making deposits, or getting cash for you. This arrangement can work well, but sometimes it backfires badly. Fortunately, you can accomplish your goal without the potential problems by setting up a convenience account or creating a durable power of attorney. Welcome back, folks, to another edition of Sweetie Kiwi. How you doing today? I hope you are doing fantastic. I'm doing marvelous. If you are doing as great as I am, go grab a cup of coffee or tea or vodka and let's roll. Today we want to talk about convenience accounts and powers of attorney and the nagging problem with springing powers of attorney. Why not just add a co-owner to your account? That's the first point we want to have a conversation around today. This may sound perfect. You just add a co-signer on your bank account. The person will receive your PIN code. The person will have access to the account. They will see all the transactions in the account and things will be very fine, right? That way, if you were sick, for instance, or just didn't feel up to keeping up on top of your monthly bills, your relative could write and sign the checks for you or even do the direct debits or transfers for you. And down the road, after you pass away, the child whose name is on the account as a co-owner could use the money in the account as a ready source of cash for funeral and other expenses. Your other assets, after all, may not be easy to get at quickly. Remember, during the probate process, some assets may linger in limbo. They may be in a legal limbo for months. In the past, the courts, and this conversation also depends upon the complexity of the process depends upon the states where you live. Because in the past, probate courts across the country have been very adamant at giving up control of the assets of a deceased person's asset too quickly, because they want to really, there's a lot of due diligence involved, and especially if the deceased person's family affairs are a little messy, things can linger on for a while. For example, if you're talking about as financial assets, because when it comes to transferring physical assets, tangible assets such as real estate, things are very easy because property ownership is a public thing. It's a public element. Everybody can go to their city, to the city the city property office and get info about the owner or the heir to a property. But what about financial assets? What about assets such as stocks, bonds, ETFs, commodities, or other tangibles, commodities, silver, gold, those collectibles? This kind of assets take more time to trace, to track, and transfer. So this is, if you add a co-owner to your account, to your bank account, the first part of the process of the issue has been taken care of, the financial part. But you need to also take care of the other issue. And this is what I want to talk to you now. There are several potential issues when it comes to just adding a co-owner to your account. And let's talk about that. So there are three major problems that I can see. Number one, misuse. Of course, you don't think your child or next of kin will use the money for anything but for your benefit, but stuff happens. Aside from complete dishonesty, pressure from a spouse or creditor could push a child or next of kin to quote unquote borrow money that never gets paid back. So your assets could be misused. Your money can be misused. So that's the first major issue when you add a co-owner to your bank account. Number two, creditors. So let's say you have a co-owner, your son, your daughter, your brother, your sister, your partner, If your co-owner gets into debt trouble, his or her creditors could try to seize the account. Remember, the key word here is co-owner. So your co-owner also owns the bank account. And ultimately, all the assets, all the cash that is currently in the bank account. So lenders can come after that bank account. In a divorce, for example, the co-owner's spouse could claim that some of the funds belong to the co-owner. So if your son, for instance, is going through a messy divorce, his ex-wife could claim that some of the funds belong to him, with all the consequences that one can imagine. The third major issue that I can see here is sibling conflict. So the person you make a co-owner of a joint account will legally inherit the money in the account after your death. Remember that almost all joint accounts come with what's called the right of survivorship. And that means the surviving co-owner keeps the money. And this is a crucial concept here in estate planning, the right of survivorship, which means that the surviving co-owner keeps the money. Is that really what you want? In other words, do you intend for the money to be split among all your children or just revert to a specific child? So you may think everyone understands your wishes, but the account co-owner will not be legally obligated to share the funds after your death. So the other siblings might be able to sue over the money and prove that you didn't mean it to be a gift, but that's a little consolation given that a lawsuit is guaranteed to severely deplete both family harmony and money. I'm not even talking about lawyers' fees here. I'm talking about first family synergy, family union. So those are things you want to think about. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of City Key, where we are still having a conversation today around convenience accounts and powers of attorney and the problem with springing powers of attorney. If you love the content's clarity and quality so far, please consider subscribing to our channel and turning on the notification bell so you are informed in real time whenever we drop a new show. And we do this every single day, rain or shine. Like, share, and comment below if you appreciate the conversation we're having here. So I was talking to you about adding the co-owners. Let's talk now about durable powers of attorney. If you want to give someone, say, significant authority over your financial matters, the best way to do so is to sign a document called a durable power of attorney for finances. Let me repeat that. The document is called a durable power of attorney for finances. So what you're essentially doing is naming someone you trust as your attorney in fact. This person does not have to be an attorney, but the legal word for it is attorney in fact. So the attorney in fact has the right to handle financial or property matters on your behalf. You can give broad or limited authority. A lot of folks are kind of concerned about this attorney in fact concept because they think they are just ceding too much authority to that person. No, you can restrict the scope of the authority that you are granting this person. When it comes to your bank account, your attorney in fact is free to spend your money, but there are two very critical restrictions. One, the funds must be used only for your benefit. And this is critical because some attorneys in fact in the past have been charged with dishonesty or with mischief, with fraud. So the funds must be used only for your benefit. And here for your benefit, I mean anything from healthcare to welfare, to your food, to your medical care. If you want to travel, you want to go on a trip, you want to hang out, you want to chill, it has to be for your benefit. It's your money after all. Think about it. So that's the first restriction. The funds must be used only for your benefit. Second restriction, at your death, the money is part of your estate. So it doesn't go to the person you named as attorney in fact. This is different from adding a co-owner. If you add a co-owner under the concept of the right to survivorship. The money goes to the co-owner. But if you have an attorney, in fact, that person does not get any cash. Before the attorney, in fact, can start writing checks for you, you want to make sure you want to take the signed, notarized, durable power of attorney to the bank, so the bank can have the document on file. Without that, the bank will not release the funds. Any funds that the attorney, in fact, request, the bank will not release the funds. Let's talk now about convenience accounts. So I've talked about durable powers of attorney. Let's now talk about convenience account. So this is another great option, and we have about 25 or 30 states, and they have something called a convenience account. So this is the kind of bank account that allows you to give someone authority to use the funds for your benefit only. There is no right of survivorship. So after your death, the money goes into your estate, not to the convenience signer. A convenience account works like a power of attorney, with the exception that the signer's authority is limited to the particular account. But it's roughly the same idea, and the same rule applies. So the convenience signer does not own the money, but can use it only on your behalf. Family members will not be certain about whether or not you want the convenience signer to inherit the money in the account either. So these accounts are authorized by a law called the Uniform Multiple Party Accounts Act, which a lot of states have adopted. Convenience accounts may be available in other states too. You just have to inquire at your bank. But the big idea here when it comes to convenience account is the word itself, convenience. It allows you to allocate temporarily authority about your money, authority over your money to someone. And that person, under the current legal doctrine, cannot inherit your money at your death. It's kind of similar to attorney in fact, because you are in a position, in a physical position, or in a mental position, or in a physiological position where you feel like you might either pass away soon or you might become incapacitated. So you are making sure that someone is there to take care of your assets. The most important thing here is that you want to inquire with your bank and make sure that the attorney in fact, or the signer, the convenience account signer, works under something called the Uniform Multiple Party Accounts Act. Very critical. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We're also having a conversation today around convenience accounts and powers of attorney, and the problem with springing powers of attorney. Now let's talk about the problem with springing powers of attorney. What is that exactly? You probably may have heard about it, springing powers of attorney. That means powers of attorney that spring, quote unquote, spring into effect when you become incapacitated. You can also call them triggering powers of attorney. So those powers of attorney come into effect when you become incapacitated. So many folks like the idea of these documents because they are uncomfortable with making their power of attorney effective while they can still manage their own affairs. However, in practice, there is a big problem. Using a springing power of attorney can cause more problems than it solves. And I'm going to give you three main problems. Or actually two. There are three, but two are more common in all 50 states. For example, delay. So instead of being able to use the power of attorney as soon as the need arises, the agent must get a determination of your incapacity before using the document. In other words, someone, usually a doctor or healthcare specialist, must certify that you can no longer make your own decisions. And in some cases, depending upon your situation, this could take days or weeks and severely disrupt, if you think about it, severely disrupt the handling of your finances. Because while you are incapacitated, and you know you are, or at least the majority of people around you know you are, and they can see it, you still have to wait for an expert to certify that. And if you have, quote unquote, some kind of rare disease or some kind of rare condition, and you only have one expert or one specialist who can certify that condition, and the person, God forbid, is somewhere on vacation or it is just not around, you're going to have to wait for that person to come back. So the springing powers, the first challenge, the first problem with a springing power of attorney is the delay. The second problem is HIPAA and privacy issues. So state and several laws, including the Health Insurance and Portability Act, HIPAA, protect your right to keep medical information private. In other words, doctors and other healthcare specialists can release information about your medical condition only under very limited conditions. So to certify your incapacity, for example, your agent, your convenience account agent, will need to provide proof that the doctor may legally release information about you to your agent. So you may be able to resolve this issue by completing a release form before you become incapacitated. However, your agent could still run into problems caused by bureaucracy or by the doctor's confusion about what is legally required. So navigating these issues could cause serious headaches and delays for your agent. So if you think about it, HIPAA and privacy issues somewhat hark back to the delay problem I also mentioned earlier. Because those privacy issues, this HIPAA constraints limits doctors' ability, limits healthcare specialist ability to release info to your agent. The bottom line here is what? The bottom line here is, if you are relying on someone else to make a decision, to make a move before your situation is being taken care of, we've got a problem. So this is the main challenge you have to account for when you think about powers of attorney, springing powers of attorney. Number one, delay. And number two, HIPAA/privacy issues. Now, let's quickly talk about incapacity, because you cannot talk about springing powers of attorney without mentioning incapacity, right? Because it triggers those powers of attorney triggered. They spring into action when you become, God forbid, the person becomes incapacitated. So to state the obvious, if your power of attorney requires you to be incapacitated, then you'll need to be incapacitated before your agent can help you manage your finances. If you make a springing power of attorney, your document will have to define incapacity. When it comes time for the determination, your doctor will have to agree with you on that definition. Let me ask you a question. What if the healthcare specialist disagrees with your definition of incapacity? Then we have a problem. What if your agent or your lawyers believes you no longer have capacity, but your doctors disagree? So these gray areas may make it difficult, if not impossible, for your agent to help you when you need it. How do you avoid these problems? You want to make a durable power of attorney that takes effect as soon as you sign it. Just make sure your agent understands exactly when and how you want the document to be used. So the degree of trust is a basic requirement for naming an agent. If you don't trust the person, if you don't trust your agent to handle the power of attorney exactly as you intended, you should choose someone else to handle your finances. If you still feel that you want a springing power, see a lawyer for help. Just want to give a caveat here, a disclaimer. This whole show is not about providing legal advice to you or to our viewers. We are a general information show. We provide information based on our research, and it is up to you to reach out to a specialist who will better understand your situation and advise you accordingly. So an experienced attorney can draft a power of attorney that is more closely tailored to your specific situation, finances, and concerns. All right, folks, this was it for today's conversation. I want to quickly recap the conversation. So I was talking to you about convenience accounts and powers of attorney and the problem with springing powers of attorney. So first, I spoke about adding a co-owner to your bank account, durable powers of attorney, convenience accounts, and lastly, the problem with springing powers of attorney. I will see you next time. But until then, remember, stay marvelous.